Fast forward, you come over channel, yes, so I'm say AGH Politics Avenue. Political stories are trending because making headlines. The generally need to be a sumo, a waha, need me on Brazil. And a lady can ambassador so be subscribe to the channel. Hit notification bell, share now for front to answer into NKB. And need my own right in sim. Now you do rap political habits in ma. Suspended Chief Justice Tokornoo Australia number 2. After say court, High Court, dismiss an application, no. Can you say ECOWAS? ECOWAS and so on, as I'm there or why I'm no say. On so nasemono, omodo musabe nkum so ayede atoso. Na esuro yi wasase yi ahemfa na woko. Sisia no. The trimpo nyina ne say International Court of Justice aho na wodi nani betwe na at the end of the day no akwa kusiki for justice ewo because ahayin dia ono so ayena dwense nya dia asem no obete ne ho ase say okwa akotena fie ne die ene kan ne obekoso akon nkonin na nkonim die nso atimi ayene dia na yemo enwura eye lawyer Martin Pebu aso eye abra wone na bedwafo ajemre na nsimu omu eyemu mpensempensemu na enya asem koto akra ene dem ni ahobrasem yemu nwuram.
Lawyer Martin Pebu, first off, as to what you think about this latest decision, abuse of court processes, that's what the conclusion the court is arriving at. What does it mean legally when a court makes that pronouncement? And for many who are out there asking what the implications are, what do you have to say to that?
The reports we have, it means not just the abuse per se, but the other part of the reportage that the court has no jurisdiction, meaning that the court didn't go into the merits of the case. So the court didn't delve into it. The issues she's raised, the court didn't look at them. That's chief among them is to say Shining Stars is not legally incorporated. That's to say Shining Stars does not exist as a legal entity. So it should not be able to petition for Chief Justice Tokornoo's removal. All that. The court says, no, I don't have any mandate to go into it. Okay, I'm not dealing with it. So it means that the court has not gone and decided that they are right, Chief Justice Tokornoo is right or wrong. No, what the court is saying that I don't have the power, I don't have the remit. It's not within my scope of duty to make such determination. Okay, and so by coming here, you are abusing the court's process. So you're using the wrong forum. You're worrying us. This is not the right place. Okay, so now, blessed, what I can say is that ruling is new learning for some of us. There were a lot of us who thought that, oh, yes, the High Court could go into that. Okay, but now that the High Court says, no, I'm not the right forum, I'm sure the Chief Justice may decide to go for it to attempt to find out the right forum. And look, to be very honest, when if they do, or even if she doesn't, this is new learning for us as lawyers. This is new learning because there were a lot of us. I also thought, oh, High Court could go into it. But from what the High Court is saying, meaning that for it doesn't want to delve into this matter, it should be the Supreme Court. I guess so, because if the High Court can't deal with it, then it means go to the Supreme Court. So it's new learning. You see, this area of the law has not been tested. I mean, many aspects of it has not been tested. When it has been properly tested, the courts will indicate so. So I'll tell you a famous example is Article 181. That's if government is entering into a contract with an international business entity. When the Supreme Court dealt with the Bawumia, Sophotone, etc. cases, and they thought that they had explained the provisions enough, they wrote it expressly that, look, we finished explaining this provision. Henceforth, if anybody has a problem with this article, you can go to the High Court. So perhaps with this, maybe we will get to that threshold when the Supreme Court gives a number of decisions concerning Article 146. then perhaps the Supreme Court will now expressly decide or direct that henceforth, if you have a problem on X, Y, Z, maybe you go to the High Court. But for now, we haven't reached there. The High Court says it cannot. This is like, if we say a common way of putting it, it's above its pay grade or its pay scale.
Yeah.
This matter is above my pay grade. I'm not going into it. That's essentially what the High Court said.
Okay, if this is anything to go by, that will leave the embattled Chief Justice with one option to perhaps head back to the Supreme Court, correct? The Supreme Court has made its decision and pronouncement on this matter, but constitutionally speaking, you agree, they could vary from their previous position. Would you urge the Chief Justice to take another shot there?
Urge for now would be a strong word for me. I know it's mild in certain contexts, but Kofi in this context is strong for me. Strong for me because, you know, from day one, I belong to the school of thought that thinks that the Chief Justice should be given a dignified exit. She should be allowed to resign. Notwithstanding that, I know some Supreme Court decisions, Paul Lutadere, and then which are is it Frankie J. Chum? No, there's a High Court Amwaku case where the Supreme Court said when they start the process, the respondent, that's in this case the Chief Justice, cannot resign. I'm hoping that somehow there should be an exception. So for me, I don't have an appetite for litigation on this matter. I wish that the Chief Justice could reach a political settlement with the President and other stakeholders so that she exits in a dignified manner.
Do you see that? Do you see that in her posture? She's heading now to the ECOWAS court, for instance, and look at the demands she's placing on the table. I believe somewhere $10 million in settlement. Do you feel all of that could be part of a politically negotiated process?
Oh, absolutely, yes. That $10 million will be thrown out of the window in seconds. No, it's because perhaps that avenue to resign is not available to her. That's why you see that, okay, then she's going 9 miles. So in this context, I once again implore our senior statesmen to come together and then perhaps approach her. And if she consents, then they will approach the President and the other stakeholders so that they negotiate something for her to go, so that she resigns. That would help us because, you see, right now it appears, looking at our state of development, we are not quite there. You know, the matter she's thrown out, you see that she's forced certain conversations that ordinarily we wouldn't have. You see, she raised issues of bribery, issues of nepotism, issues of political influence, matters that, you know, usually we hesitate to hold frankly in a no-holds-barred fashion. These are matters that when it comes to the judiciary, we are coy, we are shy about them. But I see that she's forced the conversation. And, well, that's my opinion. I'm thinking that all in all, yes, she started a conversation to a certain extent. It's okay for now. I think a political settlement where she exits in a dignified manner is better. Blessed, Kofi, let's mention expressly. This Article 146 proceeding she's facing, if she loses the case, look, it means that her record is tarnished. Can you imagine? She, her family, her children, her record is tarnished. And besides, she will lose her entitlement because that is misconduct. When it comes to, when you look at Article 146, it's misconduct. And you see, usually in our employment law, when a person is dismissed from office because of a misconduct, that person loses entitlement. And so it means that, you know, by her position, Chief Justice Tokornoo would have retired on her salary, entitled to security, entertainment, etc. All those things she won't get if she loses this case. So I'm thinking that perhaps if she's allowed to resign and then she can go with these benefits, it will help the whole nation.
Your final take on this, the point about the political resolution. President John Dramani Mahama will be very instructive in that process. But even before the hearings began, the president did not seem to take it lightly when he claimed that the embattled Chief Justice had gone out into the media circulating details of the commencement of proceedings. The president was clearly not happy about that and put that in a statement. Do you feel that the president, and knowing him very well, perhaps might want to take a different posture now, sit down at this point and listen to the embattled Chief Justice?
Oh, absolutely. Absolutely. I think generally, John Mahama comes across as a very amiable person, always smiling, all right? And so he usually exudes a spirit of reconciliation, friendliness. I'm not the only one saying, because he laughs, often in public, yes. So that's the reputation he carries as being amiable, being conciliatory, etc., right? Yes, we all know the things Akuffo did to him when he was in opposition, didn't allow him to get his benefits on time, etc. But it doesn't appear John Mahama is paying Akuffo back in his own coin, and so many other things. We could go on and on. So the key thing is, I think some statesmen need to get up and intervene by themselves. They should approach the Chief Justice, talk to her. If she agrees, then they will approach the President Mahama, and I'm sure something can be done.
Okay, yes. Let me bring in Joseph Ďisǎppǒintěd, who is a former Deputy Attorney General, also joining the conversation now via phone. Thank you, sir, for your time. So you've heard the latest. Do you feel it's all over for the embattled Chief Justice? In the words of the former member of the National Council of State, Sam Okujeto, he believes that, once the process has been triggered, it's all over for the Chief Justice.
I have. Thank you very much, first of all. And thanks to your cherished listeners and my brother Martin Pebo on the other side. Good evening to you. I'm opportune to be called upon to make commentary on this matter. And quite frankly, since its start till date, I have not commented on it because I've had other things to do. But this is the position I want to espouse. You see, she's done all that she can to stop the process of the investigation, to vindicate her right and all that, anytime she hits the rock. So, yes, you are asking me to comment in the light of that and what the Venerable Okujeto has said. You see, for me, I have spoken to other platforms and I've indicated that the process in Article 146, which is being strictly adhered to now, will lead to one and only one inevitable conclusion, namely that they will come to the conclusion without any doubt that indeed there was misconduct. If you look at the way the trajectory of events is going, that's my opinion. And so, yes, if we are going to rely strictly on Article 146, it may just be over for the CJ. But he's trying other means, democratic, other means of vindicating her right through the processes of the court. When I actually read the reliefs that she sought at the High Court, I had my reservations because, you see, most of the reliefs she was seeking at the High Court were released before the Supreme Court. And so that clearly is an abuse of the court process. So when I heard a pronouncement by the learned justice that indeed what happened was an abuse of the court process, I just couldn't but agree with the learned justice entirely. So she also thinks that before the Supreme Court, she may not get the required justice, or before the committee, she may not get the required justice. So she's exploring all avenues. She's gone to the High Court. She's not been received, in a manner that she expected. She's at the ECOWAS Court, and she's still expecting some decisions by the Supreme Court. I want to beg to differ a little from what my learned brother Martin Pebo is saying.
Yeah, Martin is calling for a political settlement.
That is what I said I want to beg to differ. You see, we are living in a democracy, and we know that our values as a people in terms of our judicial pronouncements are a guide and precedent for future decisions. So let us take a decision on this matter. Let the committee share the matter to its conclusion. Let the result be out. Let the verdict get to the public. Let justice be served, and let it be a guide for future. What he's talking about, negotiated settlement, is something he's thinking is in the interest of the TJ. But she's the one who is facing the bullet. And she says that this is the route I want to take. Right. I do not want that particular one that you are suggesting, that I go for negotiated settlement. I want to use the legal processes. Even though in a number of times she's hit the wall, she's had to lose a number of decisions by the Supreme Court in terms of interlocutory applications, and now by the High Court in terms of the originating motion that she actually filed. But the fight must continue for posterity's sake, that when a final decision is made and her rights are vindicated, it will be a guide. And when the final decision is made, she loses and she is actually removed from office for misconduct and stated misbehavior and etc. It will serve as a guide.
Okay, but how do we reconcile your point then when you say that the writings are on the wall?
You see, that's what I'm saying. I'm saying that assuming that what I have even said comes to pass, that will serve as a guide. And I'm saying that it will serve as a guide because if we don't do it to the conclusion for it to guide us, every time a process like that is triggered, then we will have to go for the other option he's suggesting, negotiated settlement. We may never have a guide in our lives. And I'm telling you that what Martin is saying, there may be some wisdom in it according to his thinking. Because what I'm afraid of is that tomorrow, another Chief Justice may be in office, a new government will come, a frivolous application is brought, the Council of State goes through it and says, look, a prima facie case has been determined, a committee is put in place, the person is removed from office. So it becomes like a cyclical kind of behavior in our democratic dispensation, that anytime a new government comes, they find something to remove the Chief Justice, so that we play political chess with the very institution that dispenses justice. And for me, I'll say that if we reach that stage, then our democracy has come to an end. Because the only institution of state, even when there were days of unfortunate days of coup d'etats and etc., the only institution of state that was not disturbed was the judiciary.
Right.
And for us, in a democracy, to now make the judiciary a political chess and ball game, and I have stated it in another platform that look at even the constitutional processes for the removal of His Excellency the President and the constitutional processes for the removal of the Speaker of Parliament. Very laborious and cumbersome and difficult, near impossible. And look at the processes for the removal of the Chief Justice. Quite easy, if you ask me.
Yeah.
So I'm saying that we need to do a delicate balance. Otherwise, what we are doing today may come to haunt all of us in future and throw us asunder.
Great
we
point
need to
here.
be very careful.
Yeah, interesting points.
Because even within a minute, even sometimes it is the case that you can give fidelity to the law, and yet mischief will be occasioned. So people are talking about the fact that constitutionally 146 is being adhered to. No doubt about that. You can give fidelity to the law and still cause mischief. And I've stated this time and again. Because if, for example, I'm not saying it is the case, but for example, I am a president and the members of Council of State, 95 to 98% of them are members of my party who have come to advise me. And I send a matter to them and I tell them that, look, I appeal to them individually behind closed doors that, look, make a determination of ABC. Do you think they will say no? But they will do it. Yeah. And then when it comes back to you, you approve. And the person is gone. I'm saying that no president will be in power forever. When there's a change of government, another government that comes and intends to remove the Chief Justice will create mischief, bring up frivolous and stamp up charges, and go through the same process. Since there is no legal challenge that you can mount to challenge the president's removal after it has gone through the other processes, that will be it. And that is how we are going to dance around for the rest of our democracy, and that will be dangerous indeed for us. Okay.
I'll move on to Lawyer Abdullahi, but Lawyer Abdullahi, just hold on for me briefly. Let me take the comments from Lawyer Martin Kpebu, if there are any, on the challenge being raised now by Lawyer Kpemka.
Well, Kofi, there is not much I can say to that. Yes, so you see, that's the beauty of the law. So I see what he means, that, okay, due process, let the process run its course. Yes, some people believe in that. So it means that we'll leave it at that. Let's see, as time goes on, we'll see the general consensus, whether citizens believe that the case should run its course or they want the political settlement.
He's speaking about posterity, the fact that there must be a laid down procedure so that next time that will serve as a cardinal point for us.
Oh, obviously, that is not lost on me. I looked at all of that, but because there isn't time, I couldn't have gone on. You know, usually when we come on these interviews, it's a few minutes. I looked at all of that and still came to the conclusion that I prefer a negotiated political settlement. I looked at all of that. I'm still of that opinion. You know, you see, like Okudjete said, it's obvious. Chief Justice Tokornoo is not coming back. We will not play ostrich. You see, Okudjete said it. So many other people have said it. She's not coming back. So why don't we do it in a more dignified manner? Yes, dignified, so that she can go with the benefits. And also it will be a lesson. You see, in terms of precedent, the fact that the gavel doesn't finally come down on her doesn't mean that it is not a precedent. There will be a precedent in terms of what Lawyer Penka is asking for. The precedent will be that, look, for these and these allegations, eventually the Chief Justice resigned. So it's also a precedent. So when the next occupant comes in, she will be he will be very weary of things like that. You know, the various things they said, buying tickets for her daughter when it shouldn't be, allowing the daughter to travel with Chief Justice. Hey, let me not go into the merits. I don't want any contempt of court, though she has gone into it. But let me stop before I get contempt slapped on me.
I was going to remind you about that anyway.
So that's it.
Okay. Justice Abdullah is also joining the conversation. And Counsel, you've heard your two fellows also talk about varied points on what the Chief Justice should be considering at this point. Where do you stand on this?
And my deepest regards to my colleagues that I haven't met for quite some time. The point about this conversation is that listening to the Chief Justice herself, you come to the same conclusion that my brother Penga arrives at, that she prefers to, as it were, use her case as a precedent for posterity. And so if you listen to her, she tells the members of the judiciary that she's doing what she's doing for them and not necessarily for herself. Now, that clearly tells you that she's determined to run the entire course of whatever legal processes that may be available to her. Unfortunately, for all of us, the only two legal forum fora she could explore are the High Court and the Supreme Court.
Woni sama horo chimi koso chana no suma no asesa jemre e wahada sene so ba den dia dumbi edumenia no ya inshia mun na insa insumu o kwasun kusukura eji politics avenue